The Committee on Government Accountability is now in session. Mr. Secretary, please call the roll.
Esslinger.
Here.
Brown. Here. Beck. Here. Black. Here. Crawford. Here. Mosley. Trent. Here. You have established quorum.
Thank you. I move that we have a quorum, and I move that we go into executive session. Do I have a second?
Second.
Received a second. I have a motion and a second. All those in favor say aye.
Aye.
Opposed, nay. Ayes have it. We are in executive session. I move that we bring Senate Bill 742 before the committee. Do I have a second?
Second.
Thank you. The bill is before the committee. Senate Bill 742, as we all know, was heard last week by this committee. That includes the Child Care Combination Tax Credit, the Employer-Provided Child Care Assistance Tax Credit, and the Child Care Providers Tax Credit. Senator Lauren. Hello. No, it's not Jay Carter. Yeah. Anyway, so this bill is before the committee. Okay, Senate Bill 742, I'll reiterate. It was heard last week by this committee. That includes the Child Care Contribution Tax Credits by the employer, the Child Care Providers Tax Credit, Child Care Assistance Tax Credit. Anyway, I move that we do pass Senate Bill 742. Do I have a second?
Second.
Thank you. Received a second. Any discussion? Seeing none, Mr. Secretary, please call the roll.
Esslinger.
Aye.
Brown.
No.
Beck.
Aye.
Black. Aye. Crawford.
Aye.
Mosley. Trent.
Thank you. By your vote of 5-2, you have voted do pass Senate Bill 742. All right. So now, are they here? Okay. So now I move that we bring Senate Bill 848 before the committee. Do I have a second?
Second.
The bill is before the committee. Senate Bill 848 was heard last week by this committee. That would prohibit state agencies from collecting fees or penalties until all administrative remedies have been exhausted. I move that we do pass Senate Bill 848. Do I have a second?
Second.
Thank you. Any discussion? Seeing none. Mr. Secretary, please call the roll.
Esslinger.
Aye.
Brown.
Aye.
Beck. Aye. Black. Crawford. Mosley. Trent. 6-0.
By your vote of 6-0, you have voted do pass on Senate Bill 848. So we're going to be leaving. Now I make a motion that we move out of executive session and resume our regular hearing. Do I have a second? Received a sec. Did I get a second?
Second.
I have a second. We will resume our regular meeting. So now we're going to be hearing Senate Bill 818 and Senator Brown. Where did he go?
He's right next to
I'm sorry. Senator Brown, begin when you are ready. I thought it was Justin. Good morning, Senator Brown.
Good morning. Thank you to the committee for the opportunity to present Senate Bill 818. For the record, my name is Senator Ben Brown of the 26th District. Senate Bill 818 states that no rule promulgated by the Department of Health and Senior Services shall delegate the department's rulemaking authority or grant rulemaking authority to any official, agency, or other department. This bill is aimed at fixing a loophole that violated our system of checks and balances and allowed local bureaucrats to essentially create 400 pages of law during the COVID-19 pandemic without any oversight or input from the public. When DHSS promulgates a rule, like any other department, there's a process for legislative oversight, where the rule would go before the Joint Committee on Rules. It's the Missouri Administrative Procedures Act. The department wrote its own rules that delegated their own rulemaking authority to local health department heads, and this delegated power went above and beyond what the department itself was even able to do. These rules that allowed one-man rule, they were found unconstitutional in the Robinson versus DHSS lawsuit, in which Judge Daniel Green was quoted as saying, "These regulations break our three-branch system of government in ways that a middle school civics student wouldn't recognize because they place the creation of orders or laws and enforcement of those laws into the hands of an unelected administrative official. While this bill would address the separation of powers issue created by the DHSS regulations that were stricken, it still fully allows the department and local health authorities to properly address within the four corners of the Missouri Constitution any public health issues that could arise. It still allows for any local governing body to enact public health policies they deem necessary through the normal legislative process or through emergency procedures established at the local level. Last year, I introduced a version of this bill, and after spending much time working with the department and LPHAs to ensure that this would not obstruct a response to any public health crisis, we were able to arrive with the version that I am presenting to you today. I believe this bill strikes the perfect balance of allowing health agencies the power needed to address imminent threats, while also creating safeguards that protect against the potential for harm when these powers are misused. Thank you, and be happy to answer any questions.
Thank you, sir. Are there any questions for our senator? All right, seeing none. So we'll open it up for for anybody who would like to testify in favor of. Please state your name and who you're representing.
You asked me to state my name, and what was that second part?
If you're representing a group.
Okay.
Yeah.
Good morning. My name is Shannon Robinson. I'm here representing myself as a citizen,
Okay.
and I'm here in support of SB818. The reason this bill is so important is because we need to make it clear that the state supports local control and local law procedural laws for lawmaking and rulemaking. This is what this bill is about. The issue here is that some regulations issued by DHSS that allowed unelected local health directors to write laws all by themselves were stricken because of a lawsuit. St. Louis County, Jackson, Cooper, and Livingston counties tried to intervene to resurrect these states' regulations. At this point, the litigation in the case has ended, and both the Department of Health and Senior Services and the plaintiffs in that case take the position that the regulations are in fact terminated. However, St. Louis County and presumably its political buddies in Cooper, Livingston, and Jackson County still think that they can write laws all by themselves related to COVID or any other contagious disease without following their own local laws for creation of ordinances and regulations. We all know this is not how laws are made. These four counties and possibly more that take the position that their bureaucrats, some of them with just communication degrees, aren't even doctors, can just write laws all by themselves without the legislative body, without any rule-making procedure, and without following local laws. We need the law to be crystal clear on this issue, on this fundamental issue. Your local legislative body makes the laws, not one unelected, appointed person. Every county has its own local laws, how regulations and rules are created. 4 years ago, certain counties ignored their own county laws for rulemaking and went rogue based on a bad state statute. While there was a suit, and even though DHSS agrees that an unelected health director can't make laws, at this very moment, St. Louis County and City are paying fancy, expensive lawyers with their deep pockets and are trying to convince everyone the contrary. Citizens cannot keep filing lawsuits every time somebody does this. It's not reasonable to ask citizens to carry this burden of clarifications on their shoulders. We need the legislature to finally clarify the rule on local health directors writing all of our health rules without any oversight at all. This bill is necessary to put a final nail in the coffin on laws being written by one person who is unelected. This one-man lawmaking has never happened before 2020, and it should never happen again. The governor has said over and over again that, along with him and the state, support local control and local laws. The state isn't going to authorize who in your local town gets to make laws. The county decides who gets to make laws in their county. That is true local control, and this statute makes it clear that the county makes the local law and not the state. We need you to be strong. We need you to be clear. We need to stop having multiple people argue their interpretation of this issue. Your action is absolutely necessary and urgent. Thank you for your time.
Thank you. Are there any questions for this witness? Seeing none, be sure you fill out a witness form.
Thank you.
You bet. So do we have anybody else who would like to testify in favor of? Come forward.
Hello, my name is Carla Gruey, and I am here testifying in support of Bill number 818 as a citizen of Missouri. on an issue that is important to preserving the American way in this state. The issue at hand is that some unconstitutional and or contradictory regulations were issued by DHSS, and they were being exploited by local health directors to write laws all by themselves. Can you imagine that? Unelected, primarily unqualified bureaucrats think it's perfectly fine to eliminate the legislative body altogether. After an extremely long and extremely expensive lawsuit, those specific DHSS regulations have been stricken. Regular law-abiding citizens such as yourselves might think that this issue has been settled. Well, 4 specific counties that happen to make up almost half of the population of Missouri have tried to resurrect those stricken state regulations. I should point out they had no business trying to resurrect or intervene because it was never up to them. But they don't care about that. After all, it's not their money. Their high-priced attorneys are being paid for with our tax dollars. At this point, the litigation is over, and both the Department of Health and Senior Services and the plaintiffs in that case agree that those specific regulations are terminated. However, St. Louis County, Cooper County, Livingston County, and Jackson County still think that they can write laws all by themselves related to COVID or to any other contagious disease without following their own local procedural laws for creation of ordinances and regulations. Of course, every county has their own local laws for how regulations and rules and laws are created, but that is not the issue. Some county medical directors still do not want to follow their own procedural laws in the future, and that is precisely why we need you to pass Bill 818. We already know of at least 5 counties. I've mentioned them: Jackson, Livingston, Cooper, St. Louis County, and now St. Louis City has joined in. They want to act like they have state-derived authority for their medical directors to circumvent their own legislative bodies and the well-established local procedural laws. Here is a copy of what St. Louis City just tried to pull, if you guys would like to take a look at it. This did not come from their Human Resources Department. It wasn't voted on by the board. No elected person with decision-making authority considered this edict. What I'm giving for you guys to look at was issued by an unelected local health director just recently. One unelected person in America cannot write laws, and they certainly should not try to trick Missouri citizens by claiming that this state has given them that authority. It's noteworthy that this particular abuse has never happened before COVID. And with your help in passing Bill 818, it will never happen again. Also, I wanted to clarify, because this is contrary to what some media outlets have published, but these offending counties, they each admit that their actions had nothing to do with a state of emergency. St. Louis County, which is where I live, boldly takes the position that it can do this at any time through its medical director without any involvement of the St. Louis County Council. That's our elected legislative branch. St. Louis County also takes the position that House Bill 271, previously passed by this body, does not pertain to these types of restrictions. And because of this, your involvement in the passing of Bill 818 is critical to end this complete disregard for the law once and for all. Thank you.
Thank you. Do we have any questions for this witness? All right, thank you for your testimony, and Senator Brown, will you make sure that that document is distributed to the committee? Okay. So do we have any additional folks who'd like to testify in favor of? Seeing none. Anyone who'd like to testify in opposition to? Good morning.
Good morning, and Madam Chair, I am in favor of the bill. For the record, my name is Jay Hahn.
Excuse
here
me,
today.
I need to clarify. Are you testifying in favor of?
Yes.
Thank
yes,
you.
ma'am.
Okay.
Good morning, Madam
Good
Chair.
morning.
And members of the committee. My name is Jay Hahn. I'm here on behalf of the Missouri Restaurant Association, and we'd like to go on the record in support of Senate Bill 818. The previous witnesses have done an excellent job at articulating the need for the bill. I think generically, as we view it from the Missouri Restaurant Association, and I had to relive most of 2020 in my head this morning, a little bit of PTSD on these issues. But nonetheless, I think what the pandemic did a good job of doing is exposed some of the problems that we have with Chapter 192. Probably was not envisioned when the General Assembly sought to pass and enact Chapter 192. Probably did not envision the circumstances that we encountered in 2020. What we saw was across the state is a patchwork of, let's just call it leased out authority. The General Assembly created the authority under 192 and granted that to the Department of Health at the state level. The Department of Health leases that authority out to the local public health agencies. By the last time I had studied this issue, and I don't have the facts in front of me, I think there were 16 different iterations of how that leased power is used across the state. So it was a lack of uniformity. What this bill does is a pretty good job at identifying how do you put that lease agreement into terms where everyone understands how to use the authority that they have. And I think that there's a lot more work that we could do to make sure that those local public health agencies understand the guardrails of the authority that they have on lease from the Department of Health. There's probably some additional language that could be added to this bill to help clarify that, but this bill's a really good start. Be happy to answer any questions.
Thank you. Any questions for this witness? Seeing none. Thank you, sir. Good morning. Testifying in favor of?
Madam Chair, members of the committee, Alex Eaton, registered lobbyist for the Missouri Century Foundation. We supported this bill last year. Appreciate Senator Brown bringing it forward. The previous witnesses did a great job of explaining why this is necessary, and with that, happy to support it and happy to take any questions.
Thank you, sir. Any questions for this witness? Seeing none.
Thank you.
Thank you. Do we have any additional folks who'd like to testify in favor of? Thank you. Let's see if we have anybody who would like to testify in opposition to. Good morning.
Madam Chair, Committee, Dave Wynn here on behalf of St. Louis County. We've had a chance to visit with the sponsor last year, the year before. We visited. I appreciate the difficulty associated with the pandemic. I know everybody on this committee, including this audience, appreciates the difficulty in administering public health under extraordinary circumstances that we were in. My testimony is going to be really limited to a few things, and I'll be happy to visit with you all a little later. The first is there's been a legal case that's been cited on several occasions. That legal case was last year. St. Louis County and Jackson County asked to intervene in a case that related to this issue. The court granted that intervention, and then the case was dropped. The fact is, the Attorney General made a statement that said the old regulations were still in place, or the new regulation, I guess, under the interpretation. There is no legal statement there. We should go back to the old law based on what happened in that court. That's when cases are dropped, you go back to the old law. What's been represented here is not accurate. Just from a purely systematic standpoint, that is not accurate. Those cases have been dropped. Theoretically, we go back to the old law. Second of all, these are not single individuals making decisions in a vacuum. The county executive in St. Louis County was elected after COVID. And so there are people at the local level that are representing that community that voters vote on every single 4 years in this case. They appoint the people that are in those positions to do this job. If you don't have the ability as a community to deal with the things that are in front of you based on guidelines provided through the Department of Health and Senior Services, then you don't have the ability to respond to these things. COVID is a couple of years ago. Lots of mistakes happened during COVID on everybody's side. There's no question about that. People acted with the information they had. Decisions are second-guessed afterwards. We understand all that. We appreciate that. and I very much appreciate the sponsor and the senator and everybody who was hurt during COVID, no matter what, for whatever reason. But it doesn't change the fact that that was an extraordinary event. We don't know what the next extraordinary event looks like. We don't know whether it's the Spanish flu or nothing. We have no idea, and that's why we have local public health agencies. These are not people that are just appointed in a vacuum. These are professionals in public health that are working really hard to protect citizens. And it's not just about pandemics. It's about boil water alerts when pipes break. It's about making sure if we have STI breakouts in communities that we do things to protect those communities. It's about responding to local public emergencies, and that's what they do. So, I mean, I appreciate the frustration people have with rules that they don't agree with, but these were not done extraordinarily outside of the law. The other thing I would remind the committee for your consideration is, after the pandemic, this body sat down. I was part of this, several others were part of it, several people behind me were part of this, and redid the statutes related to these issues and made an agreement about those statutes and how they would apply in an emergency and outside of an emergency. That is in the statute right now, and we follow those statutes. And so this issue was addressed within the Senate and in the House and passed to the governor. We're happy to provide any additional information, happy to visit with committee members, but just felt like we needed to go on record. You know, there's been a lot of things that have happened in the intermittent time, and want to clarify some of those things.
Okay. Thank you, sir. Do we have any questions for this witness? Thank you for your time. Do we have anybody else who would like to testify in opposition to? Seeing none, do we have anybody that would like to provide testify for informational purposes only? Seeing none. Senator Brown, do you have any closing statements?
Yeah, I'd just like to have the opportunity to address a couple things that were just said. David mentioned that theoretically he felt that in the case was dismissed, the regulations should go back to how they were. And I'm not an attorney. I don't know if he is, but it's been the position of the Attorney General, and even in her confirmation hearing the other week, the director of the department herself disagreed with that opinion and said the regulations were not in place after the dropping that lawsuit. So definitely the people that are in authority in that department that are charged with protecting the public health for everyone in our state seem to have a different opinion from what he just stated. He also mentioned the county executive, being a local elected official, and they should have the ability to enact these things. Well, one, shouldn't be the county executive that's creating these rules. It would be a person that he appointed, and he might know something more than I do about who's calling the shots as far as what gets enacted. I don't know, but I would just make the point that the county council is actually a more direct representation of the people. It's everyone has their own council district, and those are the most direct representatives of those districts. And I feel like you have to incorporate the opinions of the legislative body, because one person can't hope to know the true effects of any kind of order or rule or law on the diverse populations that reside inside a place like St. Louis County. I mean, you go district to district, and it varies quite a great deal. And I think that it's essential that we ensure that the legislative branch has a say, has the ability to give input, and we do not upset this three-branch system of government that our country was essentially founded on.
Thank you, sir. Oh, Senator Beck.
Yeah, so I'm going to ask the senator a question. So you brought that up, and you think the county council should have more power in this. The county, St. Louis County, has a charter form of government, and it currently spells out what the executive branch can do and not do, correct?
I believe that enacting health orders should be done through the process that's laid out in the county charter in St. Louis County, or in any county, the process that they have in place. I don't feel that you should draw upon statewide power that you claim is coming from the state level, to supersede local control.
But the charter gives the power of the executive branch to be able to appoint these positions, health department, all these other things, correct? Is that not the case in St. Louis County?
Yeah.
Don't we have our own form of government? I mean, so something like what you're trying to say, I think would probably, if you wanted to change that, it should be done on the county level. Because we have a form of government that's set up currently. I don't think the state should come in and tell the county how their government is already formed under a charter, which every 10 years they look at. They put a charter commission together. They look at, basically it's the constitution of the county and some other things. Now I know there's first and second and third class counties and all these other things. I understand that, Senator, but I was just curious.
And perhaps I should clarify. I'm not opposed to the county executive being able to appoint a director of health at all. That's not the issue here. I think that you should be able to enact rules within the bounds of what's in the county charter. That's not what I'm opposed to. I am opposed to going outside of those bounds. And even in the case of what we have a few times, the county council actually would vote to end the order, and because they were able to cite power granted to them by the DHSS, they would contradict the vote of the county council. They would vote to end the order, and then someone would go up on a podium and say it didn't matter how they voted because, I'm granted this authority from the state, and this is how it's going to be. That's what I'm opposed to.
I mean, I lived through those events. I'm not sure I remember it happening quite that way, but maybe we can have some discussions as we have in the past on this particular bill.
I'd be happy to provide documentation as to some examples where there was a conflict between what the county council voted and what was claimed to be put in place.
Okay, thank you. Any other questions? Seeing none. Thank you.
Thank you.
Okay, so no further business coming before the committee. I make a motion to adjourn. Do I have a second? Second. Okay, we are adjourned. I guess I do that.